Hello, good afternoon. I hope everyone can hear me. Meow away wolf, can you hear me? Okay, we're going to give a few minutes for a couple of more people to join our live session. Okay, good, you can hear me. Hi, DJ from Louisiana. Thank you for joining us today. It's Kay's World. Hey, how are you? Okay. For those of you who've been on here previously, you know I like to do check-ins. So DJ is from Louisiana. Jay Taz, hey, how you doing? Where are you from? Where are you currently? Sharice, where are you? Okay, hello from Philly. Hey. Who else we have? Fred from Cleveland. How you doing, Fred? All right. Hello from Honey. Hey, Karen, how are you? Denver, Florida. Okay. I'm from Chicago, but I live in ATL. Okay, cool, cool. Well, for those of you who are new to the show, I am born and raised in Dallas, Texas, and I currently still live in Texas. I live in Duncanville, Texas, which is a little suburb right south of downtown Dallas. Hello from South Florida, Mississippi. Okay, so our numbers are going up, so let's go ahead and jump into it. All right, so if you have been tuning in, we have been going through the series of the temporary orders hearing here in Texas. That is the Band-Aid effect, right? Where the judge puts something in place temporarily to get the parents onto some type of track in an order so they'll have something to follow. Again, if you are tuning in, like most of you are from different jurisdictions, just know that if you hear something that I may say that sounds like a question or something you may have relevant to what you're dealing with in your jurisdiction, be sure to reach out to a family law attorney within your jurisdiction with those questions. This information is Texas law based, so it's for informational purposes only. Obviously, it doesn't create any type of legal advice. All right. So on part 2 last week, I gave you all a bunch of information about the financial documents you need at a temporary orders hearing, the witnesses and everything like that, and the different types of possession and access schedules. Well, there were a number of people, guys in particular, that had a lot of questions about wanting to get custody of their kids. Like, Vonda, I have this situation, I want sole custody. Vonda, I have this situation. We are joint managing conservators, which means also they have joint custody, equal rights to the child or the children. I want my child to be able to live with me primarily. What are some things I need to do to be able to make this happen? Well, I wanted to go through and break that down for you. So in Texas, when you make the reference and say full custody, the correct terminology is sole managing conservatorship. So that's going back to that on part 1 where we talked about the definitions. Sole managing conservatorship. What do you have to show for sole managing conservatorship? Again, just a brief recap. Sole managing conservatorship means you have exclusive rights, all rights to the child. Does that mean that the other parent is completely cut out? No, that's not what it means. They have the right to still be informed about things that are going on with the child, but the sole managing conservator has the exclusive right to make all decisions as it relates to the child. So if the child needs to get a passport, the child needs to change schools, the doctor that they go to, any type of surgery that the child may need, anything like that. Oh, and of course, determining their residence without a geographic restriction, meaning that you can move pretty much anywhere you want to. That's what sole managing conservatorship means in regards to rights and duties. So you want sole custody. Get your pen and paper ready, guys, because this is key. When you make a request to the court, you have to be able to show why you're asking for specific things. You can't just say, okay, I want this because I'm the mom, or I want this because I'm the dad. That's not going to fly. You have these books, and you all see, I have them out each and every time because I literally have to still study. Obviously, I practice law, but in order to make sure that I'm giving you guys the appropriate information, I have to make sure that I have these as well, okay? So you have to make sure that what you're asking for, you have proof to back it up. So sole custody, you have to be able to show that the child's current living situation, environment, right, significantly impairs their emotional and physical well-being. What does that even mean? Well, let me break it down to you. You have to be able to tell the court that there are facts within your knowledge. Remember, we talked about that on part 2. Facts within your knowledge that suggest that this child could be in some sort of danger if the court doesn't do anything now, or this child could suffer emotionally if this court doesn't do anything now. And by emotionally, I'm not talking about parental alienation or anything like that. It's much deeper than that, okay? Don't get me wrong, parental alienation is real and it happens all the time, but for sole custody, it's much deeper. So what do I mean by current circumstances, significant impairment, right? Things like drug usage. You know that the other parent is using drugs or is having the child around someone, other family members, their new girlfriend, their new boyfriend, new spouse, and they're using drugs. Does that include marijuana? Yes. We talked about that on the previous, I think it was on part 2, or it could have been part 1. Marijuana is still illegal in the state of Texas, so yes. But it can't just be marijuana alone for sole custody. In Texas anyway, 9 times out of 10, if someone is just using marijuana only, the court may restrict or limit their visits, but they're not going to grant sole custody to the other parent. When you're talking about sole custody, you're talking about much heavier drugs, like your methamphetamine, your crack, your cocaine, those type of things, when we're talking about drugs, okay, for sole custody. Proof of physical or sexual abuse, and this goes beyond your child telling you something, right? It's not to say that children are not truthful. However, remember what I said, parental alienation is a real thing. So I've seen it where the child has told one parent something that was completely innocent, and that parent ran to court with it, and the child testified in court, and it was nothing like what the parent explained to the court. Okay, so when I say physical and sexual abuse, it has to be something to where not only the child has reported it, it's been investigated by CPS, maybe a forensic interview with the child, the police, everything like that, to determine the veracity, the truth of what the report is actually saying. Okay. Also, neglect. If this child is under a certain age or has certain special needs or something like that, and they're unable to stay home by themselves, and you have proof, like let's say you walked up to the door, actually knocked on the door, and your 5-year-old is in a home by themselves. Yes, that does happen all the time, believe it or not. And not only does that happen, they're watching other children that are much younger than them, younger than the age of 5. So you walk in on that situation, that's within your personal knowledge. That's neglect. That's something that you can report that the court could take into excuse me, consideration in determining whether or not you need sole custody. All right. How do I prove these types of things? What type of documents am I looking for? Well, a lot of your documents are going to be with your witnesses. What do I mean by that? So when CPS comes out and they make a report and everything like that, they assign an investigator to investigate that. That's the person keeping documentation and doing the record keeping of the actual case itself. So that person definitely needs to be in court and they need to bring their documents with them. So what you do, okay, you have to do a subpoena. And I'll go through that and tell you what you need to do, what it needs to include, okay, at a later date. But you definitely need to do a subpoena on that person. Within the subpoena, you need to let them know that they need to bring the records that are contained and that have been within their investigation that pertain to name. Make sure you name specifically the mom, the dad, and the child. You want to put all 3 of their names on there. You don't want to just put one because unfortunately, some people have multiple CPS cases and you want to make sure that they know exactly which case that you're talking about, okay? So name each and every person that you need the record for it within the subpoena, okay? And subpoena the person well before court. If you set a court date that's in December, January, I'm using an example. If you get that court date today, go ahead and get that subpoena prepared today, issued tomorrow, which means you send it off to your process server or the constable, whoever you're going to get to serve this subpoena, you send it to them right away. Because if you wait too long and you get too close to the hearing, that person does not have to show up if they hire an attorney, and the attorney does what's called a motion to quash. And we'll talk more about motions to quash when we cover subpoenas and things like that, okay? Another person you may want to bring to court as a witness to talk about the child's current circumstances, the child's teacher. If the child has been dropped off to school late every day, or they're picked up late every day, they're failing in classes, they're not getting their assignments in, those type of things, you want the teacher there to be able to testify to those things because education is taken very seriously in Texas. Not to say that it's not taken serious in other places that you all may be, but it is definitely taken seriously here in Texas. And you can lose the primary custody of your child if education is lacking with one parent over the other. A child's counselor, absolutely. Because remember, I told you all on a previous episode, a child testifying, a child telling one parent information and the court is listening to it. They're in open court. They're saying, well, the child told me. Remember, that's hearsay. That's hearsay. And we'll go over objections and rules of evidence and all that later. But a child you can't tell the court what the child said. So if you want to overcome that hearsay objection, get their counselor in there. The child is telling their counselor everything. The counselor can come in there and open the floodgates for you. Okay, that's covering sole managing conservatorship, or also known as sole custody. Now let's talk about this thing, primary. In a previous episode, remember I told you all a lot of parents try to use that word primary as a badge of honor. It's extremely misused. Primary refers to the one parent designating the primary residence of the child, which means that this is the conservator who gets to say where the child resides primarily. So if that parent wants to reside in Dallas County, that child will reside in Dallas County. Tarrant, Collin, Parker, just to name out a few counties here in Texas, if the parent chooses to live there and they're designated as the conservator who determines the primary residence of that child, that's what that means. Okay. Now, Vonda, what do I need to show of the child? Okay. I'm tea today. Very good. Okay. What do I need to show to be able to get the judge to rule in my favor? Well, one of the key things you need to be able to show is that the child currently lives with you. I represent a lot of men all the time. And they always say, Vonda, it seems like the courts generally default to the mom. The mom always gets to determine the primary residence of the child. Well, that's really because usually a lot of the children end up living with the mom by default right off. And that's not to say anything bad with the dad, but just think about it. When a child comes home from the hospital, if mom and dad are not in a relationship, the child usually is going to go home with mom, absent any type of exigent circumstances making that impossible, right? The child is going to go home with mom. So for dad, it may not be a situation right off where you'll have where the child lives with you, okay, right from the start. And that is okay. But for those situations, if a child does not currently reside with you, going into a temporary orders hearing, the likelihood of the judge making that happen is not really going to go in your favor. And not to say that it can't at some point, but if the child does not currently live with you, remember, this is a temporary order. This is not final. The child is more than likely going to still reside with the parent they have been living with currently. Okay? I want to make sure you all follow that. My dog is in here, so if you all hear sit. If you all hear moaning, that's who this is. This is Zeus. That's my German Shepherd. Okay? Let's see. Now, let's say the child is not currently living with you, but right before you all came to court, let's say about a month or two, the child had been living with you for the past year. Is that relevant to asking the court, can that happen again? Absolutely. Absolutely. Now, will the judge grant it? They may or may not, right? But you can ask for it. Remember, it's the courts want to maintain the status quo. Stop, Zeus. If the child had previously lived with one parent for all of this time and just a couple of months later it changed, that could be temporary. That could be a change in circumstances. Like, for example, we had the freeze here in February, right? Where a lot of people in Texas, they lost power to their homes, everything like that. Some people's roofs caved in on their home. The children cannot live in a home that is, where you have no water, no electricity. You have a hole in your ceiling, water dripping through it. So that could be a reason why the child temporarily lives with that other parent, right? So the court is going to take all of that into consideration. So beyond showing what the current situation is, you want the court a little bit of background. At some point, did you and the child live in the point where you and mom or you and dad in a relationship? You all live with the grandparent? Did you all live with someone else, right? So that's very important, where the child lives at the time that the temporary orders hearing occurs. If you want to be named as the conservator who determines the primary residence of the child, there are certain things you have to know. If you go in court and do not know these things that I'm getting ready to mention, you may as well save your time, your energy, and your money, right? And don't even go to court, okay? Because this is a fatal flaw that I see happening all the time. Just FYI, the parent who the child lives with primarily is 9 times out of 10 the parent who knows the most about the child. And it's not to say the other parent is deadbeat or anything like that, but you see this child frequently on a daily basis throughout the day. So if you're going to ask to determine that child's primary residence, you had better know who this child's teachers are. You better know that. Because I get you on that witness stand, you're going to have to rattle them off to me. Otherwise, why does the court need to make you primary when you don't know who the child's teachers are? Because if you don't know who the child's teachers are, guess what that tells the judge? You are not involved in their education. And as the conservator who is determining the primary residence, their education is key. It's number one. You have to know these things. You also need to know the school that the child attends. You need to know what time the school starts. You need to know what time the child goes to lunch. You need to know what time the child is dismissed from school every day. You need to know if the child is going to an after-school care program, whatever that looks like. You need to know who the daycare or after-school provider is. You need to know when they need to be picked up, the cost associated with it, all of that, okay? You need to be able to tell the court that you prepare that child's meals. So you're pretty much taking on the daily role of the parent, right? Do you prepare their meals? Do you take them to school every day? Do you drop them off? Pick them up from school every day. You do drop-offs, even if it's not school, daycare. Are you the person doing that? Do you tuck them in at night? Another big one. Doctor's appointments and dentist appointments. How often does that child go to the dentist or the doctor? Are you the one scheduling the appointments? Are you the one taking them? I'm putting emphasis on those two in particular because a lot of parents attend, dentist appointments, doctor's appointments every now and then, but they aren't scheduling them. So they can't tell you how often they occur, when is the next time. You need to know this information. You need to know if their shots up to date. You need to know what next round of shots they have coming up. You need to be able to tell the court if they have any type of allergies, if they have allergic reactions to certain medications, if they're on a special diet because of allergies, certain things that they can and can't eat. All of these things you have to know about your child. It has to be more than who their best friend is at school and what their favorite food is. That's not telling the judge anything about that child, right? You can ask the child that to get that basic information. It has to be deeper, guys. So I'm telling you all of this because I don't want you to step foot in a Texas courtroom, set yourself up for failure, and walk out pissed off. Because you will be pissed off. Because you're thinking in your head, I know this about my child, I know that about my child. My child want to be with me, I love my child. That judge is trying to say I don't love my child or that I don't know who my child is or what they have going on. That's not what they're trying to say. What they're trying to tell you is that you haven't given them enough information to suggest that on a temporary basis, it's in the child's best interest to be with you in terms of primary living. Okay? That's the reason you're not getting what you want. So for those of you out there who are listening, in Texas in particular, if you are walking in a temporary orders hearing and you come out feeling jaded, feeling like the judge didn't listen to you and all that kind of stuff, I'm pretty sure what I'm telling you is part of the reason why you're not doing these things that I'm explaining to you that you have to do. It is imperative that you do it, okay? You have to show it. I have people ask me, if I have a criminal background, does that make me incapable of the child being able to live with me on a primary basis? No, it does not, okay? Depending on how long ago the offense occurred, what type of offense it was, those type of things, you can still get custody. I got a dad custody and he had pending criminal charges at the time we went to the temporary orders hearing. He got custody of his child, sole custody over mom. Because you know what? Although dad had criminal charges pending, they had nothing to do with sexual assault or anything like that against a child, another individual. It was nothing like that, right? It was just dad got caught up in some stuff, allegedly, because we didn't even know if those charges were anything that were going to stick. They were still pending at the time. So you can still ask the court for to be named the primary conservator, the conservator who determines primary residence of the child with pending charges. You can do that because, like I was saying, although dad had those pending charges, he had a place for the child to live. The child had their own room. He was very involved in the child's education. He could tell the judge how many parent conferences that child had, how many that mom did or did not attend. He could tell me all of the child's teachers' names. That child was involved in tutoring, everything, the whole nine. So it's a balancing test. So both parents are going to come with some sort of baggage. Nobody is perfect. But when you think about the balancing test, would you rather have the parent who has pending criminal charges but does everything else for the child related to their health, education, and everything like that? Or would you rather have the parent who has zero criminal history but lives from couch to couch? Because literally that was the situation. It wasn't even house to house where they packed up and moved. It was literally nowhere to go, stand on this person's couch this night, stand on this person's couch that night. That's dangerous for a child. You know what I mean? And it's not stable. And courts want to maintain stability of the child, okay? So we are coming up on our 30-minute mark. I hope I answered you all's questions in regards to, well, not answered your questions yet, but covered the topics for part 3 in regards to what you need to show in a temporary orders hearing. This is part 3. Remember, we're breaking down the difference in sole custody and being named the conservator who determines the primary residence of the child and what you need to show in each when you go to court. So I hope that made sense to everyone. And we're definitely going to keep this up, doing this twice a week. The more people come on here, that lets me know that this information is crucial and it is helping people out there. So the more you guys are interactive, the more questions you have, the more feedback I'm getting. I had people sending me emails after the last live stream ended. I may go 2 or 3 times. I'm already doing 2 times, but I may do 3 times, 4 times a week. It just depends because we're going to cover a lot of information. Everything that is in this Texas Family Code, my goal is to give you the information about it all, not just reading you the black letter law. The black letter law is very dense. It's confusing. It's even confusing to me at times. I have to read it multiple times. So I want to make sure that I'm breaking it down to you, giving you examples so you can understand it best and you're able to articulate what needs to be articulated when you are stepping foot in these Texas courts, whether it's asking for child support, whether it's asking for a certain type of custody arrangement, requesting about a child's passport. You want to take someone to court for violating the court order. I'm going to tell you all of that. And I can't wait to get to that session about the enforcement because since the pandemic, we've seen an influx. And when I say we, I'm talking about family law attorneys as well as judges. We've seen an influx of people being denied their access to their children because of the pandemic. And I'm not saying that the pandemic is doing anything to alter that. The other parent is like, they have COVID, they can't come. We have to quarantine. Everybody in my household has COVID. It's just another way to be spiteful and nasty. But I can assure you, judges are prepared for it. Your family law attorneys are prepared for it. And I can tell you how to make sure that that person follows the order, as well as if you hire an attorney, how you can get your attorney's fees paid. So make sure you all are tuning in. Now, we are going to entertain some questions. You all had some very, very good questions on last week. I'm here in Denver, work for a major airline, and every pilot and baggage handler loves you because you're honest and real. Thank you so much, Logan. Tell them I love them as well. You know, I'm just doing my part. You know, I feel like getting on here, if I'm not going to be honest with you guys, that defeats the purpose. I don't want you going in court with bad information And if you are in a position where you're unable to afford an attorney and you have good facts and good reason to get your children, I want to be able to ensure, that you're able to do that. So thank you, Logan. Hi there, Vonda. Love your show. It's a wealth of information. Thank you for handling my son's case a while back. I'm in Florida, by the way. Love your show. Thank you, Tiffany. Thank you so much. I really appreciate that. Let's see. Criminal charges with the best interest of the child. Yes, meow, away wolf, definitely. And that's how the judge saw it too. And to my knowledge, that child is about 15 now and still lives with dad. It happens. When dependency court ended, they provided a parenting time order in this case. Father has the children Monday through Friday and the weekend with mother. Mother is not following orders. I have questions. Jonathan, thank you. Thank you for that. So, like I said, we will cover what the enforcement hearing looks like. And that's what it's called, guys. I don't want to confuse you. So when you use the word contempt in an enforcement hearing, you're talking about two different things, okay? When you go to court for an enforcement hearing, all you're doing is stating allegations within the violation itself, right? That the allegations are saying this person, the violation is listed, right? Within the violation, it contains facts, which are the allegations that's saying how this person violated the court order, right? What you're doing is asking the judge to hold that person in contempt, okay? I hope that makes sense. In family court here in Texas, there are two types of contempts. You have criminal contempt and you have civil contempt. Criminal contempt. So if the court finds that the allegations contained in the violations are in fact true, that means that the judge is making a finding that you did violate the court order and they're going to hold you in contempt. Criminal contempt means that you can be put in jail. In Texas, you can be put in jail for up to 180 days per violation. Per violation. 180 days is 6 months, right? So if you have two allegations and the judge finds that you violated the court order and holds you in contempt, criminal contempt, for two violations, you're facing up to a year in jail. I hope that makes sense. That's criminal contempt. Civil contempt means that you are going to have to pay a fine of some sort. Here in Texas, you shall, according to this book here, you shall pay that other person's attorney's fees. So if that person incurred $6,000 in attorney's fees, guess what? The judge must make you pay the attorney's fees. Now, does the judge have discretion based on what they are hearing to determine whether or not you pay the full $6,000? Yes, they do. They can say, okay, we're going to give you $4,000. Because for attorney's fees, the court has to find that they are both reasonable and necessary. Both. So everything that the attorney did in order to bring that enforcement action before the court, it must have been reasonable under the circumstances and what the law says, and it must have been necessary in order to get that person to follow the court order. Okay? So, Jonathan, if you are in Texas, what I would recommend takes place is that the very first thing dad has to do is make sure that he's following the court order. It's two-part. He not only has to show that mom is violating, he has to show that he was following the terms and conditions of the order. What do I mean by that? He has to show that he was at the place designated in the order where the child should be picked up and or exchanged. He has to show he was there at the right time. He has to show he was in legal possession. He had the right to be in legal possession of the child at that time. Give me an example of that, Vonda. Father's Day is the most easiest, right? Father's Day. Texas orders say Father's Day belongs to the father, right? Under certain circumstances where you have a situation with same-sex couples, it'll designate whether it's with mother one or mother two and so forth. But Father's Day is still recognized, okay? It say you get the child Friday as the Friday before Father's Day at 6 p.m. and you exchange at 7-Eleven. That means you have to show when you, in your enforcement action, your lawsuit, and when you get to court, you have to show the judge that you were at 7-Eleven at 6 o'clock on the Friday before Father's Day to get your child, and mom didn't follow the court order by showing up and surrendering the child to you. So dad in that situation has to document. My recommendation, if you're supposed to exchange at any type of grocery store, fast food place, gas station, go in there and purchase something and have a receipt to show that you were there. Take a picture of the location that you're at. Call the police, get an incident report. Now, not often are police going to come out, especially now since we're in COVID. Not often do they send police officers out, but you at least need to ask to get an incident report where they'll take all the information over the phone. You'll give the address, the location, what your court order says, everything like that. So when you go in court, you won't have no problem at all proving that not only is she in violation of the court order, but that you are also in compliance. And we'll go a little deeper about enforcement actions and what you have to present when you get to court, how your enforcement order has to look. It has to be very specific, okay? Thank you for that question, Jonathan. Let's see. I don't see another question on here. I know it's right before Thanksgiving. My stomach growling too. So maybe some of you are dealing with that too, where you're like, man, Vonda, it's right before Thanksgiving. I'm trying to push through and hurry up and get to the holiday. While we're waiting for more questions, let me go ahead and give you guys the next time that we will be on here. The next time that we will be on here will be, you're welcome, Jonathan. You're very welcome. The next time we will go live is on this Thursday, November the 18th, 2:00 p.m. Central Standard Time, okay? November the 18th, 2:00 p.m. Central Standard Time. I'm going to do a video so I can let people know, make sure that you all are tuning in. This is going to be part 4 of the temporary orders hearing. Temporary orders hearings, like I told you in Texas, typically they're about 20 minutes long. So I may do 2 more sessions about the temporary orders hearing because I've pretty much given you the gist of what you need. There are just some little nuances that you need to be aware of going into the temporary orders hearing. I'll also be laying do's and don'ts when you go to court, period, but definitely for the temporary orders hearings, okay? Let's see. Can a supervised non-custodial parent go to a child's doctor's appointment with a custodial parent, or does the supervisor also have to attend? That is an excellent question. So it really depends on what the terms are of the court order. If the court order says that the visits are to be supervised, that means that whoever is listed in the court order to supervise it has to be present. I've seen situations where the custodial parent can be the supervisor. So if that's the case, and that's very rare, because a lot of times these people don't even get along, but that person has to be present. If supervision is to be had through a supervision facility, then 9 times out of 10, that non-custodial parent is not going to be able to attend the doctor's appointment. But thank you for that question. Other parent is attempting to move 1,500 miles away. We have a custody agreement in place. We already live 2 hours apart now, and I commute back and forth visitation. How is it possible to get full custody? This is an excellent question. It's not possible to get full custody, okay? If you get an opportunity, if you're just now tuning in, I believe that the name is Allah. Make sure you watch this video from the beginning and see what I said about full custody here in Texas, which is referred to as sole managing conservatorship. So you're more than likely not going to get sole custody in a situation like this. However, if you're in Texas, what you can do is file a modification and ask the court to name you as the parent that gets to determine the primary residence of the child. That way, if you're living in Texas, that child's residence doesn't change. The other parent can move wherever they want to move, but the child residence stays here. If you have a custody agreement and there's a geographic restriction in there, there is a certain, the geographic restriction keeps that other parent from moving out of town anyway. So give you an example of that. If your geographic restriction says that you can only live in Dallas County and other counties that touch Dallas. So any of you who are not familiar with Dallas, counties that touch Dallas are Tarrant County, Collin County, Kaufman County, another one? Denton County. Those counties are what's called contiguous, meaning they touch Dallas. There are some courts in Texas, if you violate that geographic restriction, so let's say you move from Dallas to Houston, although that's about 200 or 300 miles, it's still outside of the geographic restriction because Harris County, which is where Houston is, doesn't touch Dallas based on it. So custody will go from have the right to determine primary residence and flip to the other one. Violation of that, it's still violating the court order. So you may want to, wherever your jurisdiction is, if you're outside of Texas, you may want to speak with an attorney in that jurisdiction to see what you can do before the move happens. Don't wait until the move happens. Be proactive, do something about it now. Thank you for your question. Is it mandatory for parents to pack clothes for visitation with the other parent? Great question, Beauty with Marie. Absolutely not. It is not mandatory. Now, if the child needs an EpiPen, if that child is on certain medication, asthma pump, anything like that, that does need to be transported between the parents, okay? And if there's a situation where you two just can't get along, then the other parent needs to purchase those things at their home. But packing clothes back and forth, that's not a requirement. Ricky T, when will you go on prime time? You know, when the Lord say it's time to go, that's when I'll move. But until then, I want to keep doing this. Honestly, I'm not in a rush to be on prime time. I mean, I've been asked, I've gotten offers, you know, to pitch to these different companies and they want to interview and they want to discuss having joint ownership of my show. The reason why I'm not in a rush to do that is because once I do that, I can't do stuff like this. There are certain limitations and restrictions on it once you're on prime time because you're under a contract with certain networks and they don't allow you to do things like this. I'm more passionate about doing this than I am about being on TV. Okay, I'm not in a rush to get on there, but thank you for your question. We have joint custody. She has physical residence. I'm also far more stable with my living situation. Allah, you got to get in court then. Get in court right away. Do not wait. Can a lawyer fees be petitioned to be paid by the non-custodial parent after a hearing? Great question. Absolutely. As a matter of fact, if you hire an attorney, make sure that the request for attorney's fees is in the petition. So when you have a petition, it has all these requests and things that you're asking the court to do. Within that petition, there will be a section about your request on temporary orders. It'll be temporary orders regarding the children. If you're going through a divorce, it could be property and children if you have children as well. But attorney's fees need to also be requested. Okay? The request has to be in there. If it is not in there, the judge cannot award it. And that is a great question too, because I'm also going to cover the award of attorney's fees on at a temporary orders hearing. It doesn't always happen. All right. I've requested attorney's fees at almost every single temporary orders hearing I've had, and I've probably only got it awarded twice in almost my 8 years of practicing, because it really depends on the circumstances. It's very specific. Please address a grandparent's rights with regard to conservatorship, from Holly Perry. Thank you, Holly. We will definitely cover that. That is going to be in part of our series about the temporary orders hearings, because people have questions. They get confused. Does a grandparent have rights in Texas? If a grandparent have rights, what are they? It's very specific. So I have to walk you through that from start, which is showing that you have a right to even be in court in the first place, asking the court to do anything as a grandparent, and walk you through what that looks like, that battle looks like after you have established what's known as standing, which is your legal right to be in court making the request. I'm going to cover all of that. Thank you for that question. Are primary and sole custody similar? They are similar in a sense, and that's a great question. They are similar. However, the major difference is that when you have sole custody, you have all exclusive rights as it relates to the child. When it comes to the conservator who determines the primary residence of the child, the rights are normally equal with the exception of two. The parent who is the conservator who determines the primary residence, that's the exclusive right that they're going to have over the other parent, and usually the right to receive child support. Those are going to be the two rights that are not equal. So they have some similarities, but they are different. Oh, thank you, Judge. We need you right here. You're very welcome. You're very welcome. Ricky T, I think your show is awesome and can't wait to see what you come out with next. God bless you and your family. Thank you so much. God bless you as well. Meow Away Wolf, thank you for your questions. You are coming with it today. How long can a non-custodial go without paying child support in general or to unemployment? This is an excellent question. The short answer is never. You can never go without paying child support. Why am I saying never? Because you accumulate back pay. Back pay comes with interest. Interest meaning like any other interest, student loan payments, your car note, it has interest to it. A monthly payment is so expensive. Mortgage payments, trust me, I know all about it. The mortgage itself is like this much, but then the interest is like this much. So you never want to go without paying child support. Now, you raised something interesting within your question. You mentioned unemployment. Please, 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 if your employment has been impacted by COVID and you no longer make the same amount of money, you've been laid off, you got terminated, whatever the case may be, if you have a court order in place, if you're in Texas, request a modification now. Request it now, okay? Because you want to let the court know that there has been a material and substantial change in circumstance, i.e. your income. They need to know so it can be reduced. Then when your income changes and employment information is received from your new employer to the Attorney General's office, then it can be changed again. But if you're unemployed and you're paying child support, make sure you're looking to get a modification. What happens when it's the non-custodial parent weekend, but they don't show up due to work or on vacation? Notice is given on the day of. There is no harm, no foul if you are the custodial parent and the non-custodial parent doesn't show up. Your only job as the custodial parent is to make sure you surrender the child when the parent shows up. That's when you get in trouble. Okay? The time that the custodial parent gets in trouble is when they don't surrender the child. Non-custodial don't show up, nothing against you, you're good. Just make sure you keep your documentation in terms of text message, email, however it is that you all communicate. Maryland, they cannot pay for months and nothing will happen. Precious loves. I mean, If you don't let anybody, you're welcome, V. If you don't let anybody know in terms of the court, nothing will happen. Okay, guys, we have reached the 10-minute mark, so I'll entertain a few more questions. Let's see. If the non-custodial does not exercise their visit, is it mandatory to make up the visit? Great question. Absolutely not. If you miss a visit, you miss a visit. Now, if the parties co-parent and it's understood ahead of time that the visit is going to be missed and they're going to make it up, you do have to honor that makeup. Why is that? Is it in my court order that I have to make it up? It's not explicitly stated. However, most court orders in Texas do order that the custody or possession schedule is followed if there is an agreement. So if the parties make a mutual agreement to change the exchange location, you got to follow through with the agreement. If the parties have a mutual agreement to not do visitation on this weekend and on another weekend, you have to honor it. Because if you don't honor that mutual agreement and that person files an enforcement on you, you can still be held in contempt. Because, like I said, most court orders in Texas have language in there that talks about mutual agreement of the parties. Absent a mutual agreement, you default to what the order says, okay? Our custody agreement says $0 child support by choice between us on our agreement. We choose on our amount. I use Cash App and keep every receipt. Is this still recognized by the court? That is an excellent question. It will be recognized by the court. All I encourage people not to do is give cash, like literally cash in hand. That's the only thing I do not recommend you do. Cash App, Venmo, Zelle, what's another one? Cashier's check, money order. Those have receipts, right? So you can take those in the court to show proof that you have been making child support payments. Now, when you send that money, make sure on the memo line or whatever, because on Cash App, it'll say 2 and 4. Make sure you put child support. Write that on every single receipt or a single memo line. Child support. Why am I telling you to do that? Because if you do not write child support in Texas, it is considered a gift. Not a gift to the child, a gift to the other parent. So make sure if you're going to be using those different type of apps to send payments, if no custody agreement is in place, then you need to make sure you're putting child support. Now, in Texas, if you have a custody order, like this question is referencing, do not send money any other kind of way. Cash App, everything like that I just said, if you have a custody order, do not use that. Send it appropriately how it's supposed to be sent, how it says in your court order. Most court orders in Texas say you're supposed to send it through the state disbursement unit. That is located in San Antonio, Texas. It means that the Attorney General's office is going to get a withholding order sent to your employer. Your employer is going to withhold the amount that is supposed to go through the Attorney General's office to the state disbursement unit, which just disperses to the other parent, okay? That's generally what it says in those orders. That's how you need to be sending child support payments. If you are in Texas, if you are under a court order to pay child support, do not send it any other way. In our court orders here, it says you will not be given credit for payments that you send any other way. And I'm paraphrasing here to not use the legalese that are in those orders. But essentially, that's what it means. You'll not be given credit. It's called informal payments. You will not be given credit for informal payments. So just follow the court order and send it how it's supposed to be sent. Is the non-custodial required to pay towards a child's tutoring and or outside school activities like gymnastics? If so, how much needs to be paid? Allah, thank you. Thank you so much for the super chat. I really appreciate it. Is that a requirement? Well, let me say it depends. Some court orders states specifically what should be paid. So if it's gymnastics, if it's tutoring, it'll normally say the parents split it 50-50. The generic rule, the general thing is no. If you're ordered to pay child support, that's pretty much all you pay, unless told to do otherwise in the court order. So absent a court order designating the parents to split or one parent to pay in full extracurricular activities, educational activities, then it does not have to be paid. Hello from South Africa. I'm glad you were able to tune in and be with us here today. We have a few more minutes left. I want to make sure that I at least try to engage or entertain everyone's questions before we convene for today and reconvene on this Thursday, November the 18th, 2:00 p.m. Central Standard Time, part 4 of the temporary orders hearing. Let me take a sip while I'm waiting on you guys to come with these good questions. Let's see. Looks like the next one we'll be talking about is enforcement after the temporary orders hearing. Can you give more background about your fur baby Zeus? Yes, I can. Zeus, come here. I'm trying to get him to stand up. Come on, baby. Come on, Zeus. Paw. Here, I'll do this to make it easier. Zeus, look, Zeus. Look, Zeus. Say hi. Look, Zeus. Say hi. Say hi, guys. This is my baby. Okay, so Zeus, we got Zeus when he's not a full grown adult yet, but he's technically still a puppy. We got him when he was about 6 weeks old. He was the runt of the bunch, but Zeus is huge. He weighs about 65 pounds. He won't be 2 until January. So you were able to see how big he is. Full-bred German Shepherd. Super loving, super protective. If you all are interested in getting a dog, especially if you have small children, the German Shepherd is the way to go. Super, super protective. It's like having a babysitter. Literally, they're not going to let anything happen to the kids. Super protective of you. One thing about German Shepherds too, they're very, very close to their male owners. So he's extremely close to my husband. He's close to me too. As you can see, he's in here protecting me. But he's extremely close to my husband. Very, very, very sweet dog. Extremely smart too. I'm teaching him how to turn the lights on and unlock the door when he needs to go outside. So he's learning. So if parents don't go to court and make an agreement, do they determine holidays and set the number of days? Is it joint custody based off a number of days per year? This is a great, great question. If you don't want to go to court and you come up with an agreement, you essentially will have to go to court to at least make that agreement legal. By legal, I'm meaning having a judge sign off on it. That's what makes it enforceable. Okay, the judge has to sign off on that agreement. You don't have to go to court in terms of duking it out. You can just outline what the terms of your agreement is, put it in an order, have a judge sign it, and you're good to go. Thanksgiving, Christmas, the child is with one parent. The child is with one parent for the morning. The child is with the other parent for the afternoon, and you can rotate the holidays and such like that. The agreement depends solely on you. Absent an agreement, the holiday schedule is just based on custodial parent versus non-custodial parent and what year versus, and what do I mean by what year, if it's an even year or an odd year. So this is an odd year, and if I'm not mistaken, the non-custodial parent has Christmas this year, and the custodial parent has Thanksgiving, and it just rotates, and it does the same thing with spring break, like that too. Thank you. He's big for a puppy. Hope he joins you in court. Thank you. He is huge. He is very big. His mom was about 80 pounds. She was huge. So Zeus will be pretty big. And I hope he joins me in court too. Greetings from Sweden. Okay, thank you for tuning in, everyone. Again, make sure you are back with us on this Thursday, November the 18th, 2 o'clock p.m. Central Standard Time. I'll answer this last question. What has inspired you to want to become a judge? Well, for one, I've been exposed to the legal community my entire life. My mom worked as a supervisor in the felony courts. My dad retired as a lieutenant from the sheriff's department, and he's now a deputy chief with the constable's office. And my husband is a police chief. So law has been around me my entire life, okay? And so I always wanted to make a difference in people's lives, just on a grander scale, which is why I'm running for judge. I see a lot of things that need to be changed. So instead of just making noise and saying what needs to be changed, I decided to be a part of it. So here I am. Thank you so much for your question. See you all on Thursday.